Catching up with Kevin Schofield here of SCCInsight.com. How are you?
I'm good. How are you?
I'm okay. So, big news today coming out of the State Court of Appeals regarding the firing of former Seattle police officer Adley Shepard. Maybe you can tell us, how did we get here and what happened today?
Yeah, so this started back in June 2014. Officer Shepard was on duty. He was called to a domestic disturbance incident where there's a bunch of things going on. He ended up arresting an intoxicated, fairly belligerent woman, handcuffed her. He was trying to put her into the back seat of his police car. She kind of leaned back, brought her foot up and kicked him in the face. And about 2 seconds later, he reached in and punched her in the face and broke the skull bone next to her eye socket. This is investigated, and he was found to have used excessive force, which was a policy violation for SPD, and Chief O'Toole, who was a police chief at the time, terminated him. SPOG, the police union, appealed this on his behalf, and this went to an arbitrator, what they call the Discipline Review Board, which is an arbitration board. And in June of 2018, they held a hearing on this, and in November 2018, the arbitration board found that the firing was excessive, overturned that, instead gave him a 15-day suspension, although it gave SPD the right to not reinstate him as a patrol officer, but had to give him a job back again, right? The city appealed that. King County Court judge overturned the reinstatement of him and said, no, the city has a right to fire him. SPOG appealed that. So there's been a whole bunch of different appeals along the way now. SPOG appealed that to the Court of Appeals, and that was the ruling that came down today. And the Court of Appeals said that the King County Court got this right, that the city SPD has every right to terminate Officer Shepard. So they upheld that termination. And I want to read you a little part of this. This is pretty fascinating. So, part of the background of this is that when arbitration is called for in a contract, like the SPA contract calls for, it can only be overturned when it has a very explicit and dominant policy that it goes against. Right. In this case, it would be the policy against excessive force. So what the appeals court said today was the decision reinstating Shepard is so lenient, it violates the explicit, well-defined, and dominant public policy against excessive use of force in policing. Indeed, the decision sends a message to officers that a violation of a clear and specific policy is not that serious if the officer is dealing with a difficult subject, losing patience, or passionate and believing that he did nothing wrong, however mistaken that belief may be. Such a message cannot be squared with the public policy against the excessive use of force in policing, which we hold imposes on the city an affirmative duty to sufficiently discipline officers. So the appeals court really came down hard on arbitration ruling and said that the arbitration ruling was just wrong. It was way too lenient, and that the city absolutely has the right to discipline him appropriately, including terminating him for this.
Right. And, this is kind of timely right now. There's so many conversations, especially around collective bargaining and arbitration. There's legislation down in Olympia. And one of the things that we hear the chiefs here say, but also chiefs across the country, is that it's difficult for them to fire officers.
Yeah, that's right. And it goes to arbitration board. In this case, there's a couple different options that are in the SPOG contract that basically let SPOG and police officers go forum shopping to the one they think will give them the best results out of this. So the state legislature and the session that's going on right now has been debating a whole bunch of different bills looking at different ways that they can reform this system, including potentially reforming arbitration, making it something where for all law enforcement agencies in the state, the rules are exactly the same. And in fact, there's one state board that does all of them. That's one option they've looked at. Another option they've looked at, which I don't think they're going to go in this direction in the end, is to just get rid of arbitration for police discipline altogether. That's That's a pretty extreme approach to take. There were some good arguments for doing that. In fact, this case sort of brings out kind of, both the sides of this. One is the city could say, in fact, this is one of the things they told Judge Robart, because this case with Adley Shepard was, you could argue, the prime reason that Judge Robart found the city out of compliance with the consent decree a couple of years back. And what the city came back and said, no, we appealed that. The system is working. We appealed it. Sometimes arbitrators do weird things, but the system worked. The courts looked at this and they overturned it, and that's part of their message today. But the other thing you can say is, why on earth should a labor lawyer be able to overturn the chief of police's experience and decision making on what the appropriate discipline is for an officer in this case, right? Which is what happened. So why would you ever have an arbitration panel overturning, the discipline decisions of the chief of police? So that's kind of, in an essence, the two decisions that are being wrestled with, or the two kind of perspectives that are being wrestled with in this case.
Right. And so what's next now? Does SPA go and appeal this to the state Supreme Court?
They could. My guess is they probably won't. The Court of Appeals has to take this case. The state Supreme Court does not. And this one now, with both the King County Superior Court judge and the appeals court coming down super, super hard and saying, look, this was clearly a mistake by the arbitration panel to do this. I think the chances of the state Supreme Court taking this are really, really low. So could SPOG decide that they want to spend the time and the money and effort doing this? They might, or they might just want to get this one behind them and move on.
Right. Is there anything else about this case here today, or the factors that have led up to it, that you want our viewers to know?
Well, again, as I mentioned a second ago, this was a case that Judge Robart, who oversees the consent decree, looked at and said, wow, I have to find the city out of compliance with the consent decree as it relates to police accountability, because just look at this outcome. Clearly, this is not working, right? And the city, as I mentioned, argued back and said, no, it is working. There are appeals up to the courts, and the right thing will come out in the end. And at this point, it's not clear whether Judge Robart is going to buy that argument or not, right? And if there's a good chance we're going to come out of this legislative session in Olympia without any real changes in how arbitration works. They might do a little bit, but they might not. If that happens, and then the city has to go back into negotiations with SPOG again, it's not clear we're going to come out with a particularly different outcome, because state law right now guarantees the police officers arbitration, right? That's in exchange for the fact that they can't strike. They can't go on strike. So arbitration is sort of the backstop that gives them a way to appeal any working condition or other condition of their employment that they think is unreasonable. That's not an unreasonable thing for them to have. But in this case, for police discipline, it can turn out some really screwy outcomes of this. So what is the right way to handle these things to make sure that police officers do get a chance to question things that a government and the police department might do to them that they think are unreasonable, but at the same time not give them such incredible leverage in negotiations that they can't be held accountable for their actions.
Right. And a lot of people might think that down in Olympia, it's just this legislation against collective bargaining with just SPOG and everything else. But actually, there's quite a few unions that are very much against this legislation. And if you know how legislators make it to Olympia, a lot of times it's union backing and union supporting that gets those legislators down there to the State House. And so the general public might view it as just SPOG, but behind the scenes and not making a lot of noise are unions that are putting pressure on legislators not to support this.
Absolutely. And it starts with, the other first responders, like the unions for firefighters. They have definitely come out, against a bunch of these potential reforms, because they would reduce their not only negotiating power, but also their ability, again, to have a method to appeal working conditions that they think are unreasonable, right? But there are a lot of other public employee unions who've said, even for, line workers for Seattle Public Utilities, potentially, Teamsters, electrical workers who said, hey, I'm not real happy with this because, this sets a really dangerous precedent for them for reducing the negotiating power of unions, right? Could this be something that's seen as specifically about police and trying to get some reform and accountability, or is this a much broader first step toward, which could be seen as anti-union, right? That's a very difficult balance to find.
Really interesting as well, because the Martin Luther King County Labor Council actually, which is comprised of all the unions here, or a majority of them in King County, kicked SPOG out during the summer. And so, now it's kind of put your money where your mouth is. So we'll see if that was just a performative action by many of the members of the Labor Council or not. Kevin Schofield, SCCInsight, thank you so much for taking the time.
Thank you, sir. Have a great day.